Welcome once again to Lehto's Law. Here's Steve Lehto.
I'm having a slight issue with my voice, a little bit of a cold, but I thought if I don't do a video today, I might lose my voice tomorrow. So bear with me. I think I can make it, but we'll see. Got a story here that Tim and a bunch of other people sent me, but Tim sent me the version from the IndianaLawyer.com. And it has to do with a house being built and a judge saying that house probably has to come down. Hamilton County judge orders demolition of $2.2 million duplex. Maura Johnson wrote this. The judge ordered the $2.2 million Geist area duplex to be demolished after finding it was constructed in violation of the Water's Edge subdivision's setback requirements. And it's been the subject of a years-long dispute between the developer and the Homeowners Association. A lot of people were saying, hey, Steve, it's a Homeowners Association story, but it's actually much more than that. The superior judge ruled that an investment group, LLC, must remove the entire two-residence waterfront structure on Lot 11 of the community, including the foundation, and return the property to its original condition. The order follows earlier summary judgment findings that the developer built the house without required architectural approval and in violation of the subdivision's 2021 covenants. So an attorney said, the Water's Edge Owners Association is very pleased with the order of November 24, 2025. The association believes that the order is correct both on the facts and law and looks forward to putting this long-standing dispute behind it. Now, I did tell you the other day about how judges can short-circuit a case if there's nothing to fight about, and that's what happened here because there was a summary judgment, which means that the court looked at the facts and said there's nothing to try here. And so apparently the house is there. You can measure where it is, and I think everybody agrees the house is, in fact, where it is. So, one of the attorneys representing the developer said his client believes there were better ways to remedy the situation other than demolition and will appeal if other options can't be agreed upon by the two parties. While we greatly respect the judge and his decision, we believe critical arguments regarding the ambiguity in the covenants of the Homeowners Association and the prior course of dealing between the parties were not considered. He said in a written statement, in addition, there are more than sufficient remedies available in simply tearing down the entire structure, which is over the setback by only a few feet. And but that's the problem, is a few feet's a few feet. You know, I can think of a couple football games where if they just gave us an extra inch on the call, we would have won the game. Just a couple inches. So the attorney says the destruction of this building does not serve the public interest, especially those that currently reside in the homes. Well, yeah, but that's not necessarily a reason to allow the law to be broken. The court found that the home encroaches on required side yard setbacks by about 600 square feet. When the litigation began, only the footers were in place. The home is now fully built and occupied. The judge noted that the developer continued construction after being warned a year ago that doing so risked very costly remediation if it lost the case. So the Homeowners Association sought a mandatory injunction requiring removal of the home. The developer argued that demolition would be excessively burdensome and the HOA suffered no actual damages. Of course, if that argument flies, then people can go, hey, we can ignore the HOA rules, all of them, and build our homes wherever we want because, no one's suffering any damages. The court determined that monetary damages were either inadequate or too speculative, citing the ongoing violation. And so understand this. I've talked before about damages, and there's different things a court can do. A court can award money. That's the most common one. Somebody sued somebody, they got a big bunch of money. The other one is equity, where the court orders someone to do something. So the question is there some way that the developer could just cut a check and make this go away, but leave the house? And the court's saying, no, that doesn't solve the problem because the problem is ongoing. It'll keep happening. The house ain't going anywhere, short of a massive earthquake or something. So the court cited the ongoing violation, limits on the HOA's ability to enforce uniform standards, and risks to property values. Because presumably one of the reasons that the HOA says these rules exist is they're trying to make sure the houses are far enough apart from each other and the footprint and the lot and all that stuff. And if there's this one non-conforming unit there, some people might drive through and go, wait a second, what's that doing there? It's a little out of place, isn't it? So the judge acknowledged that 2 families now reside in the home and will be affected. He concluded that enforcing the restrictive covenants outweighed the harm to the developer, which he described as almost entirely self-inflicted. And that is one of the things that a court will look at in deciding whether or not someone's entitled to relief, whether it is money or whether it is equity. And there's a phrase that they use of unclean hands. And they'll often say that you can't come into court with unclean hands and seek equity. Now, I'm not saying that the developer here has unclean hands, but courts do look at, okay, how did we get here? And the HOA says, we told them they're building in the wrong spot. The builder says, well, we were building a house, and we're building a house, and, but we told them they were building in the wrong spot. So, as I like to say, whose fault is this? So the judge's ruling said evidence showed the home was sold on contract to 2 tenants for about $2.2 million. Court said it would hold a hearing to determine next steps if the parties can't reach an agreement on the process for demolition. So the demolition of the building can begin 90 days from the date of the November 24th order. The judge also ordered the residents of the homes to be notified of the order, and that'd be a shocker. In his order, the judge said the parties could choose to find a solution that appeases them both that does not include demolition. But of course, the homeowner association is going to say, if we cut them slack on that rule, the rule becomes useless, and we as a homeowner association will have trouble enforcing our rules in the future when people say, well, you told them not to build that house there, and they built it anyway, and then you forgave them, so I'm doing something over here. I'm just going to seek forgiveness later. And again, that's a risky way to live your life. So the developer told the lawyer, that is the paper here, that if the parties can't reach an alternative solution, the developer will appeal the order, not just to save the building, but to solidify a legal principle that should protect every property owner in Indiana, that your land rights should be defined by public law and recorded plats, not just a shifting opinion of a private committee and an overzealous board president. The real question I'm curious about is, when was the rule enacted that they're accused of breaking? Because if the rule is enacted after they laid the foundation, that's one thing. But if it was in place before, that's another. The court also awarded the HOA its attorney's fees and costs of the case, which amount to now over $70,000. And the developer's been ordered to pay those within 30 days of the judge's ruling, but of course they can appeal that also. But when you appeal, you often have to put up a bond or post the money, so it's unclear how they'd go about doing it. I'm not sure. But I can tell you, I've done other stories about homes built in the wrong places. Famous case of the house out in Hawaii. And I did a couple videos about that. And I've talked about this before. So if I own a piece of property and somebody comes and builds a house on my property, they can't say, well, my house is here now, sell me the property. I mean, they can ask, but they can't make me do it. And so if I go into court and say, I had a piece of property and they built a house on it, a court's going to say, well, if that's true, guess what? You can sell a piece of property if you want to, but you don't have to. And the court can order them to take it down and return the property to the condition it was in before. Now, the odds of that happening really, really well, pretty slim, meaning that once they're done, they'll still probably be a mess. But the point is that that is a remedy that courts have used. So if you're a builder, you got to be real careful where you're building to make sure that you're not only on the right property, but in the right location within the property. And I can tell you, I'm very familiar with these things. I've had things built on land before. And I've walked a piece of property with a surveyor who's got one of the really nice surveying things with the thing at the top and the screen and all that. Walking around, making sure everything is where it's supposed to be. Where are the corners? Where are the edges? And then where's the thing we're going to build? Where's that going to go? How close will that be to this line? How close will that be to this line? You don't just throw darts at a map, okay? And there's reasons. And as you can imagine, that somebody comes along and says, hey, those footings are in the wrong spot. if that's what happened, it's really, really tough for a court to say, well, we know that you just kept plowing ahead even after being warned. No, a court's going to look at that and go, that's even worse. They often talk about whether you knew something or should have known something. And here it's not the question whether they should have known. It's the question, did they know it? And from the facts, it sounds like they very well could have. So we'll see what happens if it goes up on appeal. They could still reach a settlement. Now, one thing I can tell you, and there was a famous case out of Michigan years ago where somebody built a house and they later built an extension on the house. And the extension was too close to the property line. There were setbacks. And it turns out that the person next door, their home was far enough back from their property line to where the property line could be moved to allow both houses to exist just fine. And so somebody came by one day and said, hey, that extension you put in the house is too close to the property line. You got to resolve that issue. And the person who did that went to their next door neighbor and said, hey, can we buy a strip of property from you? We just need like 6 feet. I forgot the exact amount, but it wasn't much. And they said, sure, and they named a price. And the people next door said, no, we don't want to pay that much for it. It's just a strip of grass. Come on. And they said, okay, we won't sell it to you then. And the city came by and said, okay, you're still too close to the property line. Take off that portion of the house. And that's what they made them do. Now, should these people have sold the strip? It's up to them, but you can't force them to. And it turns out that strip of property is actually worth a lot of money, especially if they need it to save a portion of their house. And so these situations get really weird really fast. That's why you've got to be very, very careful. And again, like I said, get to know the surveyor and make sure you walk around and understand everything. And hope that everything's right and that the satellites are working well that day, my friend. So I made it to the end of the video without having a coughing fit. I'm so excited. Maybe I'm getting better. Who knows? But Tim and everybody else who sent that, thank you very much. That version of the story is from the IndianaLawyer.com. As it is right now, the Hamilton County judge has ordered the demolition of the $2.2 million duplex, saying that it was built too close to the other property. And the judge says that the developer and the builder should have known that, or they did know that, and they decided instead to just go ahead and live dangerously. If that's true, well, there you are. But they can still appeal. We can see what happens, or they can resolve it. And a resolution very well could be that they approach the lot next door and say, can we buy a strip of your lot? It might not work. That might not be possible, but that is something. Again, if you can't move the house, you might be able to move the property lines, right? So there you go. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Having nutrition information on a bag of Cheetos is like having dating tips on a pair of Crocs.